for the July 2020. In this month's update, we start with an amendment to the Persons with Disabilities Act. This primarily, however, is more to do with public spaces, where they have asked accessibility and standards to be included in various cultural sector and also in sports complex, residential facilities. There should be provision for persons with disabilities. In respect of the match workers, that is those who manufacture your matchsticks, there is a special security welfare scheme of the government, and the compensation under this has been enhanced. It is more to bring it to your notice that such a scheme is available rather than even the compensation amount being enhanced. Similarly, in the Maharashtra Welfare Fund, they have changed who's the person who can come and visit for any kind of inspection under the funds. The Kerala headload workers, once again, this enactment, the scheme has been brought. We are only highlighting it more to show that such a scheme exists, where people with headload workers, they have a specific scheme to regulate their employment and welfare. And this has been extended to various districts, including Thrissur and Malappuram in Kerala. In the circulars and notification section, we are seeing where Chhattisgarh is making Aadhaar mandatory for the building and other construction workers. Whether similarly enactments are going to come across in other locations is also something to be seen. Though the Supreme Court has said that Aadhaar can't be mandated, it appears that most governments are going ahead with making Aadhaar mandatory for various enactments, including, and this is one where under the Building and Other Construction Workers Act. Certain exemptions have been given by the Karnataka government under the Karnataka Tax on Professions, Trades and Callings Employment Act 1976. This is primarily for single parent, similarly for ex-servicemen and different persons with disability. For them, they're all exempt from payment of taxation. Similarly, auto rickshaw drivers, they've also been exempted. Various different organizations have been exempted, including schools up to 12th standard.
The post office
the Andaman and Nicobar Islands has revised their rates of minimum wages in the 4 categories from unskilled to highly skilled. That's a substantial increase that has happened. The Andhra Pradesh government has imposed various safety measures and obligations under the Factories Act. Quite interesting as to how they should be monitoring persons, what is the emergency rescue facilities to be had, and various other measures that keep, these are in addition to what is there under the rules in confined spaces. So different safety measures have been pointed out. We shall circulate the PPT so that you could look into it in detail on what are the different measures. The quiz this week is on section 33 of the Industrial Disputes Act. A union raises an industrial dispute challenging the termination of Mr. R, an individual workman under section 2K of the ID Act. The management now proposes to terminate Ms. Y for misconduct. Should the management seek approval or permission in terms of section 33? That's the question. Please do put in your answers in the chat box. In the across the globe section of this month, we're looking at an enactment called the Supply Chain Due Diligence Act in Germany. This is applicable to organizations employing more than 3,000 employees. So this organization, for instance, if a German company is to procure materials from India, it should ensure that the Indian supplier doesn't engage any child labor or forced labor and complies with all occupational health and safety laws of the concerned country. So similarly, whether So even if the work is done outside, even if the material is produced outside, for instance, a ready-made garment is manufactured outside Germany, maybe in Bangladesh, Indonesia, or wherever it is, it should ensure that there is 100% compliance with the local laws, including child labor, there's no forced labor, all this has to be compliant. So this is the kind of law that Germany has now passed to ensure that the materials that come inside the country are compliant with various labor regulations. Work flexibility is going on in different parts of the globe in different ways. And now we are looking here at a case of where a bank in UK is looking at how employees can be provided with the childcare assistance and covering, different leave benefits. And UK doesn't have a maternity benefit of 26 weeks, but this bank has gone to extend maternity benefit of 26 weeks. For engaging persons below at the age of 14 and 15, a franchisee in McDonald's has been fined a hefty penalty of $56,000. So this is quite a substantial amount of fine which has been imposed on a franchisee, which is quite interesting to see that even in India we have fines, but the amounts are not so huge, and this is a fine of 56,000. In the Knowledge Corner segment, we are looking at the inspection procedure in the ESA Act. Yes, today the inspection under the ESA Act has come down after the Suvaida portal has been introduced. Section 45 empowers an ESA inspector to visit the factory and ensure whether the employer is compliant with the provisions of the ESA. The various functions and duties of the employer are given. There's also section 45A. So this not based on an inspection, but section 45A of the Act requires the ESA corporation to pass an order. So if they find that an employer has defaulted in payment of contribution, they should pass a speaking order. But what happens to a large extent is they issue an inspection notice or a CAT notice that they call, and then they ask the employers to pay. And many employers, without realizing that there has to be an adjudication in section 45A, tend to make payments. But actually, even after inspection, there is a quasi-judicial proceeding under section 45A. The deputy director or regional director is required to hear the employer, and only thereafter they can pass orders. And the ESA corporation was taking a stand that the order under section 45A was not mandatory because 45A uses the word may. But the Supreme Court has held that the may should be read as shall, and therefore there should be an adjudication under section 45A order before any demand is raised on an employer. Similarly, who is to prove that an employee is to be covered or not is again a question which comes about very often. So, for instance, the Karnataka High Court, in the case that you see in the screen, required that if an inspector comes and he finds there are not covered employees, he's required to take the name, father's name, and other details of the employee, and only then he can say that I came, I inspected, I found so many people. So merely coming and saying, I came to the premises, I found 20 people or 30 people working in the premises is not sufficient. Who's the 30? What is their names? Everything should be found place in the inspection report. So the burden is cast on the ESA authorities to establish for whom they are claiming the contribution or coverage of an employer. And that's the judgment of the Karnataka High Court in this regard. And as I said, the current regime of inspection is more based on the Suvaida portal, and there is a 5-year limitation period. So any orders to be passed can't go beyond 5 years under the ESA Act. Different policies are coming about on as people want to work from anywhere. And in this case, we have where companies come with a policy where for up to 2 to 4 weeks, the employee can work from anywhere in the globe. So work from anywhere policy has been introduced by one of the companies, a tech giant, and we thought we could share that with you. We are looking at two case laws this month. The first is pertains to Jet Airways, where they were employing around 169 persons on a fixed term contract. And the union contended that such contract, as they work for 240 days, they should also be regularized into the services of Jet Airways, given the model standing orders framed by the Maharashtra government. However, the management took a stand that there was a settlement with the same union on this aspect, and therefore the question of regularization cannot be raised. The tribunal was in favor, and the High Court was also in favor of the management. But the Supreme Court observed that standing orders has a statutory force. Therefore, there cannot be a settlement between the union or workman and the employer, which is in contravention of the statutory regulation, namely the standing orders. And they held that therefore the workmen will be entitled to permanency as they are covered under the standing orders, and the standing orders provides for their permanency. The next case is we are looking at a BSNL contract labor case. They were all worked as contract labor in Andaman and Nicobar Islands, and they were retrenched. And a claim was filed for reinstatement with BSNL. The tribunal directed BSNL to absorb these contract laborers who are being engaged through different contractors. And the High Court held that no, there's no requirement. They are not workmen of the BSNL, and therefore they cannot be directed to be absorbed in the services of BSNL. And ultimately it was remanded, and the tribunal once again came to the conclusion. Division bench now has once again confirmed that they are not entitled to any remedy with BSNL. The answer for the quiz section is that the misconduct for the dispute which is pending pertains to Mr. R. Ms. Y is not connected to the dispute, therefore there's no requirement to either seek approval or permission in terms of section 33. In the Lex Posh corner, we are looking at a judgment where in-camera proceedings and statements are also taken from the complainant under the Posh Act as well as witnesses. Due to pendency of the dispute, an approval petition was also filed, and the tribunal held that the charges against the respondent was not proved, as though it's a regular domestic inquiry. But the High Court said the proceedings under the Posh Act is different, and therefore the findings of the tribunal are incorrect, and granted approval of the dismissal. We have the complaints chart for this month, and we shall also circulate it along with our PP. Thank you for joining us. We hope to see you on 26th August again. Thank you.